Welcome to today's program titled The Here and Now of BIPA, Updates and Developments in Biometric Privacy. At this time, all participants are in a listen-only mode. For those of you who are logged into the web presentation, you are encouraged to submit questions throughout the conference by typing them into the Q&A box on the right-hand side of your screen. For those interested in obtaining CLE credit for this webinar, an attendance verification code will be read during the presentation that will be required on the CLE attendance affirmation form. Please write this code down, as it will not be reread, and it is required for CLE credit. Copies of the webinar recording and materials, along with the CLE attendance form, will be distributed to all attendees in the days following the webinar. On the next slide, you will see a legal disclaimer. At this time, I would like to turn it over to our first speaker for today's program, Danielle Case. Danielle, please go ahead.
Thank you. Good afternoon, everyone. Thank you for joining us today to discuss this ever-changing landscape of the Illinois Biometric Information Privacy Act, which we affectionately know as BIPA. My name is Danielle Case, and I'm an attorney here at Seyfarth. I have been counseling companies on BIPA and defending BIPA class actions since they began flooding the court system a few years ago. I'm joined here today by Ada.
Thanks, Danielle. I'm Ada Dolph. I'm a partner in Seyfarth's Chicago office and labor and employment group there. I have extensive experience as well with BIPA litigation, including a case where we had oral argument in front of the Seventh Circuit on the first BIPA case up before the Seventh Circuit. So I think it's easy to say that Danielle and I are both BIPA geeks and know it inside and out.
I'll accept that title. Thank you. Next slide, please. So next, we just have here our agenda today. We assume that many people on this line have been watching this statute as it relates to your companies and as you've seen it in the news. And maybe you've also attended our prior seminars. So we're going to start with giving a brief refresher or overview of the Illinois BIPA, as well as highlight some things that are going on in other states that has been changing. Then we're going to go to item number 3, and we're going to focus on some very recent updates on BIPA decisions and laws, as many probably anticipate, including the Timms case that was just decided a few days ago. Next slide, please. And we can go to the next one.
Okay, so we'll start with just a brief background. Many of you have probably heard a lot of this already, but we want to make sure you have some context in terms of the developments that have been happening. So the Illinois BIPA, as we call it, was originally enacted in 2008, and it was largely motivated by the bankruptcy of Pay by Touch. And you can see that throughout the statute. It's written in such a way that it's very focused on consumer use and collection of biometric information, but it is not limited to that. BIPA sort of sat dormant for many years, and then I would say in late 2017, we really saw a blast of these cases being filed, and it's continued sort of unabated since then. Because of its recency in terms of litigation, there are many provisions in BIPA which are working their way through the courts now. At the outset, almost none of these questions were answered. We're starting to get some answers from the Illinois Supreme Court as we go along. An important point is that to proceed in Illinois state court, you do not need to have an actual injury. The Illinois Supreme Court in the Rosenbach versus Great America case concluded that alleging a statutory violation, that is, that any portion of the statute was not complied with, was sufficient to have standing to proceed with the litigation in state court. There's a different standard for the injury required to proceed in federal court. Next slide, please. So what is biometrics? And we are still figuring that out, or courts are still sorting that out. At its fundamental level, it includes a retina or iris scan, fingerprint, voice print, or scan of hand or face geometry. And these have been decided in different ways depending on the technology that's being used. There is some language that suggests you could exclude biometric information that's derived from one of these originating sources. But for the most part, the courts have found, for example, scans of photographs or videos and scans used for artificial intelligence are scans of face geometry and squarely under the statute. The other one that we've seen obviously squarely falling under the statute, but is continuing to be litigated, is the fingerprint scanning used for timekeeping. And that's largely been the focus of these cases. And then with regard to voice prints, they do not include voice recordings, but any technology that uses voice recognition. So there is also in the statute some exclusions, as we just discussed, and then there's a kind of a catch-all, which is continuing to be explored as well by the plaintiff's bar, essentially any information, regardless of how it is converted, based on an individual's biometric identifier. And I'll turn back to Dave.
Next slide, please. So there are three main buckets of compliance requirements for BIPA. The first is notice and consent. The courts recently held, an appellate court held last year that, well, let me say this. So before someone collects biometric information, captures it, or obtains it in any way, the company must provide written notice and written consent. Obviously, that means it can't just be verbal or understood. It has to be something provided in writing and obtained before ever collecting and storing biometric information. And as I mentioned, the Illinois Appellate Court held last year that the timing does require that it be done before any of these actions are taken. It can't be done after. Next item, bucket for compliance, is protection of data. This requires that employers exercise reasonable care to protect biometric data. That is something that has been largely untested in the courts. It's not usually a violation that plaintiffs allege, but know that that is something that companies are required to do, is to make sure that they are protecting any biometric data with the same reasonable care that they would with any other sensitive information. And then finally, the last bucket of compliance is retention. Companies that intend to capture or collect biometric information must provide a written policy that is publicly available. What is publicly available is not really tested by the courts. There's arguments as to what that means, but it must be publicly available that tells the person who you're collecting this information from what you are doing with the data and how long you are keeping the data. And there's a 3-year limit on when the data may be kept after the user's last interaction with the company.
And I would just add, under the notice and consent column, the statute contains this somewhat unusual language that says that a legal representative can provide the consent on behalf of an employee. And that has proven to be important in some of the preemption cases and the collective bargaining cases we'll be talking about a little bit later.
Absolutely. Next slide, please. And here we just kind of describe more about the standard of care. Here's the language from the statute. And again, as we've said, this is not something that has really been litigated much in the courts. Next slide, please. So BIPA is unique compared to statutes that we're going to talk about in other cases because it's the only statute that allows a private right of action, meaning that individuals can sue companies on their own and of course join to file lawsuits and class actions, which is what we're typically seeing in all cases. When they file a lawsuit, they are entitled to damages of $1,000 or actual damages, whichever is greater, for negligent violations, and $5,000 or actual damages for intentional or reckless damages or reckless violations. It also allows a litigant to obtain reasonable attorney's fees and costs. Next slide.
So as we mentioned, Illinois passed the Biometric Information Privacy Act in 2008. It is somewhat unique in that it contains a private right of action. So it's the only state privacy law that contains a private right of action that has been found to apply in the employee-employer context, at least thus far. Texas has something similar, but it has no private right of action. It's enforced by the state's attorney general, and that's the same for Washington's similar biometric privacy law, which was enacted in 2017. We are seeing some activity in Texas by the state's attorney general beginning to open some enforcement matters there, which is very new as of 2022 and potentially an outcome of the attention that these cases have received. We've not seen that same activity in Washington so far. And then what I'd add is there's a few jurisdictions, for example, New York City and some other locations that have city-centric biometric privacy limitations that you should take a look at if you operate in those areas. Next slide, please. What's consistent across these statutes is that they all place restrictions on the collection and storage of what has been referred to as biometric identifiers. Typically, they require an employer, or in the case of a consumer-facing statute, to provide notice and get consent before collecting and storing the biometric data. Consent is all that's required under the Texas law. And as I mentioned, New York City has a relatively new statute. It's focused primarily on commercial entities, but there are questions that are open as to whether it could apply to an employee-employer situation. That requires a posting at the location regarding the use of biometric information, which is somewhat unusual. And as Danielle pointed out, employers are required to exercise reasonable care, and that's consistent across these statutes as well, that this material be treated with the same care as medical information or other private personal information. And the laws tend to provide for civil relief. And as mentioned, BIPA sort of provides for all the remedies that you could obtain, as well as attorney's fees for a prevailing party, although even that piece of the statute is somewhat ambiguous. Okay, next slide, please.
All right, now we're going to talk about some recent decisions. And actually, there has been a lot of activity just this year in the past month. Next slide, please. So we're guessing that many people have heard that the Illinois Supreme Court decided one of the biggest questions in BIPA matters from both sides of the bar, and that was, what is the statute of limitations? That decision came out last week. The case is Timms versus Black Horse Carriers. That decision was aptly decided on Groundhog Day because, spoiler alert, the court extended the longest statute of limitations possible, 5 years. So backing up to provide some background, BIPA does not specifically set its own statute of limitations in the statute like some Illinois statutes do. Because of that, over the past few years, when this litigation has been pending, plaintiffs have been arguing that the 5-year catch-all statute of limitations applies to all BIPA claims. Defendants have argued the opposite. We have argued that a 1-year statute of limitations for privacy matters governs this act because it involves the publication of matter involving a right of privacy. And a right of privacy has been noted in, for example, the Rosenbach case in relation to this statute. Although not at issue in the Timms case, defendants over the years have also argued that a 2 or a 3-year statute of limitations could have applied. 2 was the statute for provision of statutory penalties, and 3 years was the statute of limitations under the Consumer Fraud Act. However, the 2- and 3-year arguments were not at issue before this court. So again, just a few days ago, last week, the Illinois Supreme Court decided this issue, and we do have some clarity moving forward. Now, BIPA has 5 different subsections of violations, A through E, they're referred to, and 2 of them, sections C and subsection D, essentially prohibit different types of disclosure of biometric information. So the court looked at those subsections separately to decide whether the 5 or the 1 year for privacy statute of limitations applied. In taking a look at that and analyzing it, the court did say that although a 1 year limit could apply to the 2 disclosure subsections, C and D, that applying the state's catch-all 5-year limit to the entire act creates more consistency. The Illinois Supreme Court also discussed that the legislature's intent back in 2008, which is now nearly 15 years old, was that the lawmakers said the full ramifications of using biometric technology are still unknown, which was their what they viewed it back in 2008. And based on that initial concern, the Supreme Court held that a 5-year statute of limitations better supports the lawmakers' intentions. So going forward, we will be obviously using the 5 years that the Illinois Supreme Court held. So what does this mean? Practically, plaintiffs' firms have been operating under the 5-year statute of limitations for years now. They've been doing so in the context of settlement discussions and in litigations. So have the courts for the most part, except for in the appellate decision right prior to the Illinois Supreme Court's decision. So practically speaking, you know, we kind of were operating under the same class and the same number of people that fall within a 5-year statute of limitations. We do still have hope in the White Castle case, which the Illinois Supreme Court is still pending before. We're going to talk about that in a little bit. Many circuit courts and district courts have been staying cases while waiting for this decision, but they've also been stayed based on the White Castle decision. And so we expect that, and based on what we're seeing, a lot of those cases will continue to be stayed until that White Castle decision comes out. However, plaintiffs' firms are seeking to lift those stays, filing motions to do so, and actually asking to brief that issue. This also means that plaintiffs' firms continue to be emboldened. We can obviously expect that settlement demands may increase, but also that this decision has emboldened plaintiffs to continue to target new technologies under BIPA because the statute remains a lucrative option. All right, we can go to the next slide.
Okay, so as Danielle mentioned, we're expecting some decisions to still come down in 2023. We essentially moved Tim's from this section to the slide before after we got the opinion just a few days ago. And the stays that Danielle is talking about are happening throughout this litigation because so many questions, so many fundamental questions remain unanswered that a lot of the appellate courts have been staying until they get an answer from the Illinois Supreme Court. So we can expect sort of those fits and starts as these decisions come before the Illinois Supreme Court and are finally resolved. So the case that Danielle mentioned, the White Castle case here, it is significant because when you combine it with Tim's, it can be an amplifier on the damages, a significant impact on the damages. So the questions at issue in the White Castle case is, when does a violation accrue? And that's really important now that we have a statute of limitations. Does it accrue when an employee first scans their fingerprint and then it's converted to an algorithm used by a time clock? Or does it happen every single day that the employee punches in and out for lunch or breaks and that sort of thing? And those are significant, obviously. So we've had some back and forth on that. Obviously, from the defense side, we're looking for minimal penalties, and it should be, from our perspective, once per participant or per plaintiff who has in fact had their fingerprint scanned or their biometric information obtained. And that was the basis in terms of this case. It involved the biometric finger scan timekeeping. Initially, What's interesting about this case is it's been certified over and over because the decisions have been concluded to be sort of fundamental to Illinois law. So initially, the district court considered this issue. The defendants asked for it to be certified, and the district court did, in fact, certify it up to the Seventh Circuit. The Seventh Circuit, in turn, analyzed the issue, and the defendants again asked for it to be certified to the Illinois Supreme Court, and the Seventh Circuit agreed to do that. So now it's in front of the Illinois Supreme Court. It's fully briefed. An oral argument was held in April 2022. And really remains unknown what the decision will be. I will say, however, most of these decisions have not been going defendants' way. But the multiplier here, if you cannot really determine if a claim is time barred, or if you think of the number of swipes that an average employee would have per year, it turns the damages into astronomical damages, and certainly defendants will be arguing those are unconstitutional. Another case we're waiting for is the Walton versus Roosevelt University case, which is also up before the Illinois Supreme Court. This one addresses on the state side of things whether union member claims are preempted by the Labor Management Relations Act. Going back to that provision I mentioned earlier, where a legal representative can consent on behalf of an employee, it's been found in the Seventh Circuit under the Railway Labor Act that the collective bargaining agreement there and the dispute process that accompanies the Railway Labor Act ensured that these cases should not be decided in federal or state court. That same logic has been applied to collective bargaining agreements under the Labor Management Relations Act. The Seventh Circuit has already held that the same logic applies, that these claims are preempted by those collective bargaining agreements, which contain generally a broad management rights clause that allows the employer to institute, the manner of work. And you've had some of those in place with the consent of the union for years. So now it's in front of the Illinois Supreme Court, who will decide that from an Illinois state law perspective. Next slide, please.
Now we're going to talk about some cases to continue to watch in 2023. Many people heard, and this came out in 2022, that there was the very first ever BIPA jury trial. And that was the Rogers versus BNSF railway case. You may wonder why we have that up here as something to watch in 2023, because that's old news. It happened in 22. However, it's still going. Now, so as background, this jury trial took place in the Northern District of Illinois, which is Chicago, before Judge Kennelly. And unfortunately, it resulted in a very large verdict of $228 million for a class size of 44,000. Some background on the case: BNSF hired a vendor to operate this biometric equipment. And the equipment required drivers to scan their fingers in order to gain access to BNSF facilities. Interestingly, BNSF used a vendor to operate this technology, and actually both parties, the plaintiff and BNSF, disputed at who actually possessed or owned this equipment. That said, BNSF claimed that its vendor did the collecting and that they received and stored the data from the finger scans on the vendor's server, on the vendor's own property as well. The plaintiff alleged a single count against BNSF of whether the railroad violated Section A of BIPA by requiring that the drivers use and scan their fingerprints on this third-party equipment without giving them written consent or written notice. Before trial at the motion in limine stage, the court held that common law principles of vicarious liability apply under BIPA, even though that language is not in the statute, and that BNSF could be vicariously liable for the actions of that third party. That third party was not a party in the case, and so that it was essentially an empty chair argument. In the end, I think was a shock to a lot. of people. The jurors found that the railroad acted not negligently, which would have given them $1,000 per violation damage, but that the railroad acted intentionally and recklessly towards the class members. So the reason why we have this up here of something to watch in 2023 is because BNSF has since moved for a new trial and to amend the judgments. They argue, among other things, that the damages are unconstitutional because the class has suffered no actual injury, and they also contest whether they should be held vicariously liable. The parties are briefing those motions. They also engaged in settlement conference, which the court reported was unsuccessful. So we anticipate that the district court will decide that issue. And if it doesn't, I suspect either way it goes, we can expect that the case will be appealed. The other case to watch in 2023 is the Mosby versus Ingalls Memorial case. This goes to some language in BIPA that provides an exclusion for information collected, stored, used for healthcare treatment, payment, or operations under HIPAA. In this case, the nurses were required to scan their fingers on a MedStation device in order to access patient medications and provide patient care. Defendants obviously argued that this information and this collection should be excluded from BIPA. However, the First Circuit held that that information is not excluded under the healthcare provider exclusion. Interestingly, the decision, one of the appellate judges who issued the opinion was Judge Raymond Mitchell. Judge Mitchell presided over many BIPA cases in Cook County until last year. He also presided over the McDonald versus Symphony case in the circuit level, and that was a case that was appealed to the Illinois Supreme Court regarding whether BIPA claims are preempted by the Illinois Workers' Compensation Act. In November, the defendants filed a petition for leave to appeal this Mosby decision, and a few weeks ago on January 25th, the Illinois Supreme Court accepted that appeal. Next slide.
I would just add on the Rogers case before we go ahead. I found it interesting that there the judge deferred to the jury to determine how many violations of the act had accrued, which is different. Sort of that's the issue that's in front of the Illinois Supreme Court in our other cases. So here the jury determined that it was one violation per plaintiff, multiplied times the most stringent penalty of $5,000 per employee. The way that it was handled then assumes that every plaintiff's claim was timely, in that they're arguing that no matter when the swipe occurred, it was within the statute of limitations that applied. So some unique issues there.
Next slide, please. So looking forward, again, in 2023, as we mentioned, we are seeing lawsuits where the plaintiffs are expanding the technology that they are targeting. There was the first voice print settlement that came out recently, but beyond voice prints, there's a lot of other technology that companies should continue to note and analyze whether it would apply under BIPA. There's also a growing trend by plaintiffs to use and cite to BIPA lawsuits, BIPA settlements under other causes of action in states outside of Illinois in order to expand privacy actions. And as we mentioned, the Attorney General in Texas has filed suit under their biometric act called KUBI. And we expect that that will increase the trend of privacy actions, not necessarily by the Attorney General, though we expect there might be more there, but also privacy actions under state law. Next slide. This is the CLE code for everyone on the line. It is SS4654. And next slide, please.
Lastly, we want to leave you with some information regarding what's happening at the legislative level regarding BIPA. As you can see, the courts have not been coming to employers or companies' rescue. Most of these decisions have not been favorable. So next slide, please. Currently, there is an Illinois House bill pending, HB 1230. This amendment to BIPA excludes or carves out healthcare employers, and that's its primary focus. There was a bill last year, HB 559, that Seyfarth worked very closely with the Illinois Chamber of Commerce to draft, which modified or answered a lot of these questions that were waiting for the courts to answer. It also had an opportunity for an employer-employee to cure the violation 30 days after notice of the violation to get in compliance, because reasoning that compliance is really what everybody wants out of this statute, more so than gotcha penalties. But obviously that bill did not pass. It died in session. So my suggestion is, if this is a concern to you, do contact your legislator. They are listening to the companies. They are hearing stories about these lawsuits being brought against, mom and pop companies who are simply using technology that has been offered to them by third-party vendors. So that would be my final words on that, is contact your legislator if you're interested in making change. And thank you for joining us.
Thank you to our presenters. This concludes today's webinar. Thank you for attending.